Chapter 13 is going to look at plain view, consent, vehicle, and administrative searches. So let's start with plain view. Plain view is generally not considered a search, although it's referred to as search. So basically, if you're legally in a location, you can see this particular object without searching anything or moving anything, and probable cause exists to seize the object, you can search and seize. Well, you can seize it. It's not actually considered a search. So if I ring your doorbell, you invite me into your home, and you have a ton of cocaine on the table, and it's within my view, and I'm legally there, I can seize that. So in 1971, in Coolidge v. New Hampshire, the police are investigating the murder of a teenage girl. The AG is acting as a justice of the peace and issues a warrant allowing the police to search Coolidge's car. However, warrants have to be issued by neutral judicial officers, not prosecutors. And because the Attorney General is a prosecutor, they don't really have the right. They're not a neutral party. The state, however, still sought to admit the search based on a search incident to arrest, being in plain view, and an automobile exception. So in Coolidge, the court did strike down the search because of who issued it. So first of all, what do we mean by observation? It's not a search if items are not hidden. They're in what we call plain view. Okay, I can't move an item in order to find the serial number to know that it's a stolen TV. I can, however, move to a better vantage point to view something. Most courts will allow the use of a flashlight or binoculars, and it doesn't have to be an accidental discovery. So in Horton v. California, the police got a warrant to search for stolen goods. During the search, he did not find goods, but he did find weapons in plain view and seized them. And the court said that this seizure is considered plain view if these three conditions are met. And these are the conditions we just talked about. The officer is in the area lawfully. They have a lawful right to access the object, and the item seized is immediately apparent as evidence of a crime or criminality. In 1986, in California v. Ciraolo, Mr. Ciraolo is growing marijuana in his backyard, but it's invisible from the ground because of the fences. So the police use some planes, they fly over his property, and they got a warrant to search his property. The Supreme Court said that the search was valid, that there was no need for a warrant if flying over the property. The fact that the defendant built a fence around his backyard did indicate a subjective expectation of privacy, but that's irrelevant because the police are able to see it with the naked eye from public airspace. So remember, you have to be in the location lawfully, okay, and that does include aerial searches. Observations made from a police aircraft qualify for plain view, and things that are on public property. So in order to have probable cause to seize it, you can't seize it simply because you suspect a crime. The facts have to indicate it's more likely than not, so preponderance of the evidence, that the item is evidence of a crime or is contraband. And you have to be able to do that without searching the item for clues. If there is no probable cause, you could still use that discovery to continue the investigation. So you could go and, along with other facts, swear out an affidavit to get a warrant and then come back and search the location. So let's talk about open fields doctrine. The police can enter property that is not enclosed, and they can even trespass on private property. Evidence then that is discovered in open fields can be seized. So the curtilage, right, which is that area right around the property there, notice it's fenced in, okay, that's not an open field. But see this area to the right where there's an open field, that would be considered admissible. Okay, this is established in Oliver v. U.S. and UDV Dunn. So this relies on the history and wording of the Fourth Amendment. So farmland and other open spaces are not included in the persons, houses, papers, and effects specified in the Fourth Amendment. Historically, we have protected the curtilage, which is the enclosed area immediately around the house, okay? And that generally expands to those areas, but not to open fields. Expands the amendment to those areas, but not to the open fields. Open fields doctrine doesn't really have much use in an urban setting, but it is very useful in searching for clandestine marijuana cultivation. So even though someone has built a fence and put a no trespassing sign, this doctrine does apply. Okay, what about abandoned property? The key point we want to think about when we deal with search and seizure is there any expectation of privacy? Is there a subjective expectation? So that looks at the efforts a person took to protect their privacy. And is there an objective expectation. Privacy interests exist that society is willing to protect. So, what does it mean when you abandon property? You deny ownership or leave it without the intent to exert control over it. So the fact that it's abandoned indicates that we no longer have any interest in it, especially if we leave it in a public place. So abandoned property doesn't have an expectation of privacy and can be searched and seized without warrant. So a place we see that is with trash, okay? It happens to be the night, I believe it's Tuesday as I'm recording this, okay? It's the night I have to put out my trash. So trash that's in an opaque bag, a bag that can't be seen through, and placed on the curb for pickup by a garbage truck. Okay. Now, if it's in a dark bag you can't see through, that could indicate some subjective privacy interest. But in a court case from California, they said there's no objective basis for this expectation, right? So dumping it in the trash means something's been abandoned. What about an item in the trash in a private home? You still have a right to reclaim that item. Hiding something in an open area accessible to the public, that could go either way. Discarding something while being pursued by the police but prior to arrest is considered abandonment. So you're getting chased by the police and you toss some drugs or you toss a weapon into the bushes. That's considered abandoned and we don't need a warrant for it. Okay. It's also not as, well, I guess it's a search. But if you consent to something, you're basically allowing someone access. In order to consent, you have to have the authority to do so. Okay? So one thing we have to do is we have to make sure we know who can give consent. So it has to be voluntary, but the police don't have to inform someone that they can decline. Okay? I don't need reasonable suspicion to approach somebody and ask for consent. It might also be implied by an action. Now, if I tell you, hey, I have a warrant, so you might want to just consent, that's not voluntary. Okay? You're basically acquiescing to power. If the police have guns drawn on you, that also weighs against consent being voluntary. Other things we might take into consideration is the education and intelligence of the suspect, any attempts to intimidate them, and whether or not the suspect already knew his or her rights. So who can consent? Well, you have to have authority over the area, okay? You can rely, however, on a reasonable appearance that the person lives in a house or owns that business. Ownership is not essential. Again, we're looking at reasonable expectation of privacy. If there's two parties that have the authority to consent, either of them may consent. And parents can consent for a minor, but this is kind of complicated. So you're a young child living at home, the parents can consent to search their room and possessions, but older children, teens, may have their own privacy interests. Paying rent or parents recognizing a child's right to exclude them from the room can also indicate the parent cannot consent. Teens may also have an expectation of privacy regarding something that's locked, that's kept within their room. So even if their parents can consent to the search of the room, if they have something that's locked, that might be considered a reasonable expectation of privacy. Very young children do not have the authority to consent to the police entering the house, and they generally do not have the right to consent to searches of their parents' rooms or other private parts of the house. Now, when we're dealing with someone on probation or parole, they also have very limited Fourth Amendment rights. So some states do permit a search of their homes on less than probable cause. Others say basically one of the requirements of probation and parole is that you're consenting to searches. This is considered necessary in order to properly rehabilitate and deter criminal activity. So whoever consents to the search sets the conditions of the search. They can limit it by geography, by time, or for a certain item. If they discover something, though, then the scope may widen. Once consent has been given, officers can search anything in that area, including closed containers, unless you've placed a limit on that. Now, at any point, you can withdraw consent and say, I no longer consent to this search. What is found during the search, however, may be the grounds for probable cause for an additional search. And it may also indicate that some other exception to a warrant requirement applies. So plain view accompanies a consent search. Anything seen during the search can be seized if there is probable cause it's connected to a crime. In your vehicle, you have a lesser expectation of privacy. Okay, there's extensive exposure to public view, there's detailed licensing and safety requirements, and the fact that a vehicle is mobile means that there's a different level of urgency in the ability to destroy evidence. A motorhome is treated like a vehicle because they have the ability to leave the scene. If it's hooked up to utilities or otherwise immobilized, then it's treated like a home, like a regular dwelling. So if somebody gets pulled over and they're getting arrested, and the arrest of any occupant can lead to a search of the entire vehicle. This rule has been expanded to situations where the person arrested was a recent occupant of the vehicle as well. Any search incident to arrest covers the person and area under his or her immediate control. So that means the passenger compartment and any items inside are subject to search. The entire passenger compartment is viewed as the area where the person may reach to obtain a weapon and or destroy evidence. However, it has to occur when the arrest occurs. You can't go back and do it later on. Everything in the passenger compartment can be thoroughly searched. Briefcases, glove compartment, and the console can all be opened. You can also search without a warrant if the police have probable cause to believe evidence is in the vehicle. We don't need an emergency to justify a failure to obtain a search warrant. But the search is going to be tied to the nature of the probable cause. So once you can justify the search under probable cause, the officer can search anything in the care that is large enough to conceal the item sought. So this could justify searching a purse that belongs to a passenger who isn't actually suspected of criminal activity, and it can include weapons for officer safety. There's no time limits. This can be very extensive and complete, and it can be done at the scene, or the vehicle can be towed and then it can be searched afterwards. If a search is not done immediately, though, the prosecution has the burden of showing that no one tampered with the vehicle. In U.S. v. Roch, the court ruled that search of a vehicle based on probable cause can be as extensive as the one a judge could authorize if given an affidavit. Closed containers can be searched on the spot. You don't have to seize them and obtain a warrant before opening them. What if you are taken into custody, right? You're pulled over, you're taken into custody, and then your vehicle is towed and impounded. Well, the police can search impounded vehicles, but it has to be part of basically the routine and the way they deal with things. So they have to have they always, every vehicle that's impounded is searched for an inventory. You also have to have a legitimate reason to impound and search it. So the concern here is the search done for an inventory purpose or to search it? This is generally considered less invasive than searches for evidence of a crime because we're basically inventorying things we can observe. Looking inside the spare tire, removing panels, and cutting upholstery are not okay. But looking in the glove compartment or the trunk are okay. That should say trunk, not truck. Okay, vehicle searches can also be based on reasonable suspicion. Okay, so say we're going to search a car for weapons during a field interview. Well, there has to be specific articulable facts. So again, facts that you can state that cause you to believe that at least one of the occupants of the vehicle is involved in a crime. And there has to be at least a reasonable suspicion that the vehicle contained weapons the suspect might use against the officers. This permits them to search the entire passenger compartment, but it's more limited than a search incident to an arrest. So the only thing you can really look for here are weapons. Non-custodial arrests also fall under this rule, right? So basically a traffic ticket. Officers, again, have to be able to state facts that cause them to suspect the weapons were present. Outside the vehicle, the outside of a car parked in a public place falls under the plain view doctrine. What is seen can then be used to establish probable cause for further actions. This does allow officers to look for the VIN number, but you cannot do it if a vehicle is parked on private property. So in 1983 in Michigan v. Long had run his car off the road. The police arrived and found him acting erratically. So they search him in the inside of the car and they find marijuana. Then they conduct a protective search of the trunk and found 75 pounds of marijuana. Okay, remember though, we need two prerequisites for a reasonable suspicion search. Articulable facts led the officer to believe that the party was engaged in a crime, and reasonable suspicion that there may be a firearm. What about a vehicle search in a non-criminal investigation? Well, there's not a lot of case law on this. So police investigation is not related to a crime or the search for a criminal suspect, criminal evidence. So what about like if you find an abandoned car? The Supreme Court does authorize searches not related to the investigation of a crime as part of the community caretaking function of the police. So you're going to search an impounded car in an unguarded lot for a gun the driver had the legal right to possess. This is considered justified because it's done to prevent vandals from stealing the gun. During the search, imagine evidence of an unreported murder is discovered. This is an exception to the search warrant requirement that has not been fully developed by the Supreme Court, so you want to be careful in relying on this. Roadblocks have a seemingly contradictory rule. So this allows the police to stop all cars without cause, but not to randomly stop a few cars. Okay. Generally, we use these for sobriety checkpoints. Sometimes they use them for safety issues, checking people's brakes or taillights. So you can use it as a sobriety checkpoint, but you can't use it to detect illegal drugs. We also can't use it to check people for outstanding warrants. We can use a roadblock, though, to question people about a recent crime. In a 1990 case from Michigan used random sobriety checkpoints to search for intoxicated drivers, and this was upheld because it's advancing a substantial governmental interest, right? It's in the government's interest to prevent drunk drivers. What about administrative searches? Okay, this covers basically regulated industries. People who perform checks for fire and building codes to make sure that someone is in compliance. Okay, in order to get these kind of warrants, you need a statement of a legislative purpose. And probable cause needed for this is different than for a search warrant. Because the purpose of a warrant is to protect somebody's privacy from being invaded. It's designed to prevent harassment by frequent needless inspections. So in an administrative search, we have 3 requirements. There's some regulatory process supported by a government interest, right? So think about like fire codes. A warrantless inspection is necessary to further this regulatory process. And then the statute limits the discretion and advises owners of the limits. This applies to both residential and commercial buildings. And these warrants are pretty rarely used because most people are willing to let an inspector come in and perform their job. Supreme Court cases do establish some exemptions from this. So firearms dealers, selling alcoholic beverages, junkyards that dismantle cars, and safety inspections under the Federal Mine Safety and Health Act of 1977. So in Camara v. Municipal Court in 1967, a San Francisco housing inspector sought to enter Mr. Camara's residence. The inspector did not have a warrant but claimed a right of entry under the old case. The Supreme Court held that administrative searches without warrant violate the Fourth Amendment. But if there's a health or safety violation, there's no probable cause necessary. So, what are some examples of an administrative search? Well, ICE doesn't need a warrant to check for illegal aliens or undocumented workers at the workplace. Fire inspectors checking for regulatory reasons, this does require an administrative warrant, and it might also be required if someone is suspected of arson. Typically regulated businesses, so like health department codes, health codes for restaurants, regulatory rules for nuclear reactors. Okay, and that covers Chapter 13.